Despite cohabitees being the largest growing family type, cohabiting couples who separate do not have the same legal rights and they can't make the same financial claims as a married couple who are separating. And it doesn't matter how long that relationship has lasted. So there is no such thing as common law husband and wife. So you can be in a cohabiting relationship, sharing expenses, paying towards the mortgage, even raising children, and that may not mean that you can make financial claims in the event of a relationship breakdown. If you're in a cohabiting relationship and you're concerned that you may be in a vulnerable position, speak to your partner, because quite often we find that couples just don't know that if anything were to happen, that they would be in that very vulnerable position. So speak to your partner, see if any changes can be made in relation to property ownership, setting up a joint account, making sure you're providing for each other in your wills, and also perhaps nominating pension benefits in the event of death. If you're in a cohabiting relationship and separating or thinking about separating, then you really do need to assess whether there is anything that you could potentially claim. There may be claims that can be made against a property. That's to do with property and trusts law, and it's possible that an interest may have been acquired in a property known as a beneficial interest. It's a complex area of law and it needs specialist advice, but that's something to look into. If you've got children, then aside from child maintenance, there may be other financial provision that you may be able to make an application for in relation to lump sums and housing, and that's under Schedule 1 of the Children Act. But again, specialist advice would be necessary.